thank you so much for coming to this talk. Very pleased to be here. And thank you to Rupam for his talk just before this, segueing nicely into mine. So just a brief introduction about me before we get into things. I am a games lawyer at media and tech firm Sheridans here in London. I work with developers and publishers of all sizes, national, international, on basically all of the legal matters that surround the creating and releasing and publishing of games. As this work basically means that I focus a lot on intellectual property, IP, because this is what is at the heart of games and games law. I also do a lot of work on the AI side of things, particularly on the legalities around where that intersects with games and creative media and talent. And fortunately, the combination of these things is exactly what we are here to talk about today. One bit of fine print, because lawyers love that. None of this is legal advice, I'm afraid. This will be a summary of things to be aware of when navigating that funny line between AI and IP. So this, as I say, this talk will focus predominantly on intellectual property, IP, and the practicalities of how to use AI tools in a way that doesn't infringe other people's IP and also helps to protect your own IP within the context of this technology. I'm just going to start by framing the situation by looking particularly at a typical AI use case, generative AI use case, to help isolate the fault lines, the areas where issues most likely to arise. And I mean, people here would have been obviously familiar with AI and its uses in game development for many, many years before this whole generative AI boom. I mean, this is what the games industry is particularly strong at, using technology, pushing the boundaries of technology for creative ends. So why is it that recently, what is it that's different about generative AI that has caused all of these legal controversies, all of the sort of controversial headlines and court cases that we've seen recently? Essentially, it comes down to the data sets. This is where so many of these issues arise. As you will be well aware, generative AI tools rely on vast data sets. These will often include a great number of original creative works made by humans, often of humans. Cats in this case, I don't know. And these original works that make up these data sets, these will be protected by various rights, IP rights and related rights like image rights. And that's where many of these issues will arise. So just to take a step back for a second, what are these rights that I'm talking about? Like, from a rights holder's perspective, what is the rights holder's inventory that's relevant here? So rights holder. And the first one is an important one to mention, obviously, copyright. This covers a wide range of creative works, literary works, art, text, dialogue, code, software, music, and it doesn't vest in ideas. It vests once an original creative idea is written, drawn, coded, expressed in some tangible form. And then it just arises as a matter of law. In the UK, you don't need to do anything more. There's no registration process. Copyright has vested. It won't protect, though, anything generic. It has to be original. It has to be that creative process that made it your own, which is an important point that we'll come on to later as well. Next up, trademarks, also important. If you think of these as words, as logos, as a kind of a badge of origin, a marker, a stamp to say, this is what company various goods or services or works belong to. So like the word Nintendo, the Nintendo logo in the circle, both of those would be trademarks of Nintendo. I also mentioned design rights. slightly more niche IP right in some respects, but very useful, particularly in this context, very relevant. And it's used to protect things that have a particularly unique shape or pattern or layout. So if you think buildings, maps, cars, weapons, all of these might be protected by design rights as well. And the last one I mentioned here is image rights. And the reason I've put it in quotation marks is because, strictly speaking, under English law, there's not specifically an image right per se. It's more a bundle of different rights of actions that you can use to protect someone's image, certain attributes like their voice. This could be, misuse of private information or confidentiality, personal data, passing off, which is where you're misrepresenting that someone has endorsed something when they haven't. So it's not strictly an IP right in that sense, but it is definitely worth mentioning, particularly it comes up a lot with respect to deepfakes and digital doubles. So now that we have this brief overview of the relevant rights, how do these react with the collection of works that make up a data set? And I think it'd be helpful to look at a specific example for this. So I've gone for Lion, which provides various data sets that are used for AI image generation platforms, public data sets. And some of these data sets are billions of images. And the question then is, okay, so do those rights we were talking about apply to these images? Yes, they would. These are these images created by people who, in most cases, won't have given any express consent for their works to be included in these data sets. So what does that mean in terms of the use of these images? At a base level, copyright infringement would happen when there is copying of that image. So in this case, for example, when the clip embeddings are downloaded. So knowing this, how is it that these data sets are allowed to exist? And this is because, again, at a high level under English law, there is this exception that says that if you are using works without permission, but it's for the non-commercial training purposes, then it's fine, it's allowed. The reason being it's for sort of the academic research purposes. If you've got some clever PhD student who wants to research new AI tools, they shouldn't be precluded from doing that because of lack of access to data sets. So that's the rationale behind this exception, and that is how the likes of Lion data sets exist. So let's pretend then, for argument's sake, you have a company that comes and wants to use these public data sets. And they want to provide a service to people. They want to create maybe they sell ad space, maybe they charge a premium to create AI image generation tools. That's a commercial offering. It's not non-commercial. So that exception doesn't apply. Hence legal issues, hence all of the court cases, hence all of the discourse around this. So knowing that we have knowing where we stand with the data sets, with the platforms, I'm looking at this from particularly the perspective of everyone else who is creating the outputs, who is using these tools. Where does that leave everyone else? Does that mean that everyone is therefore precluded from using any generative AI? Obviously not. But there are just some things to bear in mind, some practical steps that you can take when using this technology. So we'll go through these. And the first thing, which also echoes what Rupam was saying in his talk, first thing you want to think about often is whether what's the situation with the data set? Do you know if it's licensed or unlicensed? If you're not sure, that doesn't automatically mean that you're not then automatically infringing third-party rights. It means you just need to tread a bit carefully, and that starts with looking at the prompts, the inputs that you're putting in, the keywords that you're using to generate output. Don't input anything that is going to specifically target a third-party IP. Keep it general, keep it generic. There is a big difference between an image of a cat in a car compared to an image of Garfield in a BMW. The second one, you're going to be laser focusing on Garfield's and BMW's protected works, causing a bit of an issue. So keep it general, keep it generic. And with this in mind, you also want to think about confidentiality. When you're putting in these inputs, don't put any confidential information in there, any personal data in there, because even if you have some kind of pro tier paid subscription, that doesn't, then there's some kind of stealth mode that allows you to mask what you're doing from the general public. That doesn't mean that the platform doesn't have access. In almost every case, the platform will still have access to what you're inputting and also the outputs that you're generating. So just be careful of that to avoid inadvertently infringing an NDA or something. But say we've done this, we have generated our output now. You still want to be careful to check it, to clear it, to make sure that there aren't any third-party rights slipping in there when they shouldn't be. And for this, we'll go back to that inventory of rights we were looking at before. So, are there any logos, Nintendo logos lurking in the corner, for example, or does some of that artwork look a little bit too similar to a protected piece? Like, cat looks a bit like Garfield or whatever. Are there any faces that look a bit too familiar, a bit like, particularly celebrities? So still clear it like you would any other creative work, particularly if this is going to be part of some external product, if you're going to be using it in your game, in the finished product. And with that, when you're thinking about how you want to use the output, internal ideation, less for risk. External uses, as I say, you're clearing it. You also want to think about ownership of this output, what rights you have to actually own it. And this is a vast topic in and of itself, whether you can own AI-generated works. I mean, the short answer is it depends what jurisdiction you're in. In the US, for example, copyright doesn't vest in AI-generated works. You can't own the copyright in that. You can only own it to the extent that you have edited it. And even then, you don't own the underlying AI-generated work. You only own the bits that you have edited. But by contrast, in China, copyright has vested in AI-generated works. In the UK, it's slightly different again, in that you can, copyright in an AI-generated work, a computer-generated work, belongs to the person who made the arrangements for it, which, depending on the platform terms and conditions, also something you want to check is that you is at the platform. We'll get onto the platform terms and conditions in a second as well. But basically, it's a shifting legal landscape. It's not that clear. So if you want to feel secure in your ownership of these works, in AI-generated works, edit them, make them your own, have that creative process, that sort of original thought, that human hand to make it your own. But then, as I say, platform terms and conditions are also very important that you check those, as I say, for what is the position regarding ownership. Do they grant you ownership off the bat? Fine. Sometimes if you are a company, you have to get some paid subscription tier in order to own the output. There might be restrictions, limitations on how you can use the tool, on the inputs you can, on the prompts you can input, on the, whether you can use the outputs for commercial purposes. And also, you want to check what access the platform has to your work. Very often there will be a license back to the platform saying that they can use whatever you've put in there, whatever you've created to train their model. So just be aware of that. Now, looking a bit more broadly, now that we have this context of kind of where the key issues lie and how to, if you're someone going in and using these tools, what to think about, more broadly, what are the things that you can be thinking about to protect your own IP? And straight away, there's quite a straightforward and easy one that's very effective, which is putting some kind of express disclaimer, an express opt-out on your website, anywhere public-facing, to say that you don't authorize the use of your works for AI training purposes. And this is actually a requirement under various pieces of legislation, if you want to sort of circumvent that exception we were talking about where they can be included in data sets for non-commercial purposes. So if you don't want your works to be included in data sets, you're going to need an express opt-out. It's quite easy to do. I think the likes of Meta, Adobe, Squarespace, they actually give you that option for an express opt-out. So that's quite an easy one to do. Consider some watermarks, like digital watermark signatures. If it's images, we're talking about image cloaking, can be very useful. I mean, tools like Glaze or Nightshade, worth looking into. But if, despite all this, you still suspect that your works are being used in a way that you're not happy with as part of a data set, you can always consider as well a data subject access request, which can be quite effective, actually. I mean, talk to a lawyer before you do it. But yeah, it's definitely one worth thinking about, and one that, yeah, we know can be an effective way around this. And the last one, it's kind of a slightly different angle of like, if you can't beat them, join them. There are companies, agencies who will pay now for you to provide works that they can use to train AI models. So it might be something you might want to consider for certain for your works, just charge to license them as a little additional revenue stream. But anyway, I appreciate that this is quite a few different things to think about. So to finish up, basically what I'm going to do is I'm going to try and distill all of this into a checklist, run through these just to kind of help clarify what I was talking about. As I say, first thing, data sets, licensed or unlicensed. Often they don't say, but just helps you understand the risk profile when you're going ahead and using this technology. Also, if you're creating it yourself, you know that that's the first key thing you want to be thinking about. If you're using a third-party tool, check the T's and C's, check the terms and conditions, all those points we were talking about before, ownership, restrictions on use, access to what you've created. Don't put any confidential information or personal data into any kind of publicly available tool. Keep any inputs, any prompts, generic and non-specific as possible. So we don't want to be targeting third-party IP. Remember the Garfield in a BMW example. Have that human input. Remember the ownership position. You want to make it your own. Everything we were also talking about with respect to copyright. You want to have that creative process, that original thought. And lastly, once you've done that, check it. Still just clear it like you would with any other work. If you think, that this is going to be in your final product, just do a final sense check to make sure that you're happy that this is kind of ticking all of these boxes. And just for a couple of bonus points, some final things to think about just generally across your business. As Rupam also mentioned in his talk, having an AI use policy is incredibly helpful, not just for yourselves within your company so that you all within your team understand kind of usage guidelines and where the key risks are, but also it's quite helpful to demonstrate to potential investors or insurance companies that you've done your due diligence, you understand the risks when it comes to using AI, and you know how to navigate them in a sensible way. And yeah, you could even think about doing some training for your team so that, as I say, you're all kind of on the same page to supplement this policy. And additionally, better still, have some kind of tracker that helps you, see exactly what tools have been used for what, whether this is for internal or external purposes, and have as many of the considerations we've talked about here in that to, again, give yourself some reassurance and also anyone else. And then, yeah, pop up a disclaimer if you don't want your works to be included in data sets. It's a very nice, quick and easy one to do. So I appreciate this is probably a bit of a whistle-stop tour, but hopefully this helps to at least give a bit of an understanding of some of the key issues that can arise from game developers' perspective, how to mitigate the risks associated with this, some practical steps to take when using this technology safely. I mean, it's as I say, it's very much a shifting legal landscape. But this doesn't mean that we can't use this technology. In fact, having this understanding where the risks are, how to use this technology safely and ethically, and importantly, creatively, that gives you the sort of the security to move forward and use it in a way that you feel comfortable with. You can start taking creative risks with it, just not legal risks, which is what we want. So I'm going to pause there, because I think I would stop there and open up to any questions if anyone has anything they'd like to ask.